All right, you may be seated. We've had a panel change. I have Judge Evander to my right, Judge Cohen to my left. Kendall versus Lifestyle.
Judge Palmer, Judge Evander, Judge Cohen, good morning. I'm Joseph Flood on behalf of Plaintiff Mary Kendall and the appellant here. May it please the court. We are here on appeal of a grant of summary judgment in favor of Mr. O'Connor's client.
Reserve any time for rebuttal?
Yes, I would like to reserve 4 minutes.
All right, when the yellow light comes on, you'll be into your rebuttal time.
Okay, and if I knew where the yellow light was, that would be...
Here.
Oh,
I'll
there.
put the beeper on. When the beep goes off, you'll be into your rebuttal time.
All right. This is just like at home with my wife. Okay, good. We are here on a grant, the appeal of a grant of a summary judgment based on an exculpatory clause that presents some of the identical issues that were presented to this court in the Stanislaw versus Give Kids the World case. And I note that I'm a newcomer. I know Judge Evander is a newcomer. I know we have the concurrer and the special concurrer from Stanislaw, and we have counsel for Stanislaw here. So we're the new kids on the block in this case, but at least with regard to the dispositive issue as it relates to this particular summary judgment, it's essentially the identical issue that was raised in the Stanislaw case, and I'm sure I don't have to tell you about your own precedent, but there is a split in the districts as with regard to what is required in terms of the language. All of the districts, including this district, require and agree that in order to be effective, an exculpatory clause, because supposedly they are disfavored, must be stated in clear and unequivocal terms. And that is because they shift responsibility and they relieve one party of the obligation to use due care and put it on another party that the courts have indicated is typically the least.
And we've had all, we've gone through these arguments on a number of cases, the Give Kids the World, the argument in the Plancher UCF case. The one thing that you've got here is that you've got an assumption of the risk paragraph that says that the member understands and voluntarily accepts this risk and agrees that LFF will not be liable for any injury, including without limitation, personal, body, or mental injury, economic loss, or any damage to the member or the member's guests, et cetera, resulting from the negligence or other acts, failures to act, or omissions of LFF or anyone on LLF's behalf or anyone using the facilities. And that's a clause that was not present in any of the cases that we've dealt with. Why, why doesn't that distinguish this case from those cases and be dispositive?
Okay. And it was, that's a great question. It's almost hard to read how confusing that, as you were reading it, as lawyers, I'm trying to follow it and it's almost incomprehensible, but that's in there's a couple good answers. First of all, that's in a completely separate paragraph that is not the release from liability, the exculpatory clause, which is
liability needs to be released once you've assumed the risk for that particular negligence.
Well, the case law is clear. First of all, this was not an issue that was raised at the trial court, the assumption of risk part and the negligence claim in there, the word negligence. So that's something that's being raised really for the first time here. But in direct response to your question, the case law that applies to an assumption of risk makes it very clear that in order for an assumption of the risk to apply, there must be record evidence that the releasing party specifically understood the risk that they were assuming. And in this case, it's absolutely clear that my dear poor client, who's bipolar and schizophrenic and had never been on a treadmill in her entire life, had no idea what risks she was going to be assuming, and so that paragraph absolutely could not apply. All of the case law, at least as I read it, and this court's, and the other 4 District Court of Appeals, indicate that in the release from liability paragraph, which is about twice as long and even more confusing than the assumption of risk paragraph, clearly does not indicate that Ms. Kendall or anybody else would be releasing Lifestyle from their own negligence. I suppose the example that I would give, as I was thinking about this last night, apparently they believe that if someone was in much better shape than me and was lifting weights at the Lifestyle, lifting heavy weights, and a Lifestyle fitness employee, one of their trainers, was texting, had the headphones on, was sort of breakdancing, as negligent as could be, not paying attention in any way, and was backing around and joking around and texting, a complete want of care, and stumbled into the weightlifter who was lifting 400 pounds and caused him to drop the weights and break his neck, that somehow this buried boilerplate that does not make clear that the member would be releasing Lifestyle from its own negligence, that Lifestyle would not have any responsibility for that. And that cannot be the law. That is absolutely absurd. Quite frankly, I think Ms. Kendall's situation is essentially the same. I mean, it was...
Negligence asserted.
The negligence asserted in this case was for Ms. Kendall, who was grossly obese, had never been on any real exercise equipment, certainly never had been on a treadmill, that there was not any orientation or training or even showing her how to use this. And the reason for that, the record evidence was that Lifestyle...
So your theory would be that Lifestyle would have to take your client around to every single piece of equipment within the gym and give an explanation of how to use every single piece of equipment in the gym.
And we didn't actually get that far in the case. We didn't get to that part of the evidence, but it would be our argument that minimally that they would have an obligation to provide orientation and at least ask Mrs. Kendall what equipment she might want to use, since this was her very first time there, and explain those pieces of equipment to her.
This would apply to all customers. They would have an obligation to determine what their level of experience was, whether they've used this equipment before, et cetera.
And that's an excellent fact question on another issue, but I believe yes, and quite frankly, Your Honor, that's exactly what they do for the paying customers. For the people who come in who aren't silver sneakers on Medicare and on government assistance like Ms. Kendall was, who, they just, the person who even signed her in wasn't the sign-in person. But with the paying customers, they assign them to a specific sales representative who signs them in, and then they get them to a personal trainer so they can try and presumably sell some more services, but they do take those people for orientation, and I think...
I know it doesn't show, but I've been going to gyms for, years and years and years, and never have had anyone take me around a gym and describe how every piece of equipment in the gym works.
And I would say probably they would take one look at your chiseled physique and realize that there would not be any need for that. Obviously, you would be
many of them for that very reason.
That comment may get one vote, but the other two are very unimpressed.
Certainly the most fit panel in the state of Florida on this day. It's interesting you raised that, and I know it's not in the record, but on other days I represent the Central Florida YMCA that has 26 family centers, and we do that routinely with new members. We orient them, ask them what they want to do, fill out sheets.
Well, it might be a good business practice, and it is a little out of the breeze, but on the other hand, if there's a basis to affirm, we can consider that, but you're asking us to impose a legal duty on all gyms to give an orientation for each piece of equipment to every single new customer, regardless of, if an Olympian came in or an overweight elderly woman. what's the basis of that request to impose that legal duty?
And that's actually a great point. With all due respect, I don't think that's the point that we're here on, and that is going to be
The other arguments already on a number of cases.
Let's get to the good
More
stuff.
interesting.
And I actually toyed, by the way, with having Ms. Kendall come here, but she would have had to ride with me because she doesn't drive, and I didn't really know that I wanted to bring her over and then have her sit here and come back.
You'd have to explain how the seats in your car work and seatbelt.
But quite frankly, one look at Ms. Kendall, and any one of you would realize that she would need some assistance. She is grossly obese. It is obvious that there is something either emotionally, psychiatrically, or mentally difficult. And that's why, and I'm not asking the court to impose an across-the-board standard, not that it would not be appropriate. I think that these machines are very dangerous machines, especially for the elderly, for people like Ms. Kendall. Maybe for all of us, they might not be, but there is certainly a large class of people, and the silver sneakers, the people who most need the help, the people on assistance.
Yeah, it seems to me, I can tell you, I'm an elliptical guy, not a treadmill guy.
Me too.
But I've been on, treadmills, and perhaps for someone, as you describe your client, getting onto the thing is probably as dangerous as anything else, but that's an open and obvious, you've got to step up. It's like going to walking up a set of stairs. It ought to be a fairly obvious risk. When you push that button on a treadmill, it starts out slower than at a walking, crawling speed. And so your client would have to take actions and be hitting buttons to make that thing increase in speed.
And you're exactly right. The actual mechanism of injury, Mary was a little, she wasn't exactly sure that happened, but it was exactly then when she was getting on, and it may have already been on. There was a witness that told one of the lifestyle people who was standing next to it that it was still running, and again, if you've never been on one, I'm not sure you'd know whether that's okay or not, but that Ms. Kendall was trying to hit the button, trying to slow it down, and actually kept speeding it up. Since I seem to be on a roll with this, as an aside, off the record matter, one of my best friends from years ago was a guy by the name of Bill Curry, the football coach's son, who's an elite athlete who got hurt stepping on a treadmill, and it got going too fast and had a terrible injury. So they are dangerous machines, and it is not out of the ordinary or ridiculous that there should be some orientation, especially for people like Mary.
Let me ask you this. You're the example of the person lifting weights and an employee bumping into him. And it's a little bit like our court dealt with in Blanchard, where the assumption of the risk was not what you'd expect. The negligence, what you'd expect with the football players, it's a dangerous game. Someone may tackle wrong, practice maybe run wrong, but you certainly don't expect a lack of medical care when you're injured. You expect that, when you see a football player hurt on the field, the trainer comes out. You don't expect that no one will come out and they'll leave the football player on the field and continue the action, or when the Blanchard case was in a training facility. The example you gave is kind of something you wouldn't really expect as far as where the assumption of risk language was going to. While on the other hand, it would seem that your client, that's exactly what the assumption of risk language was designed for, that, we have this equipment, you have a risk if you don't know how to use it of being hurt. Do you see a difference, and should we consider that difference between a likely incident and one that's very unlikely or not expected?
And that's an excellent, a great point, and I think it underscores the difference between the two paragraphs that we're talking about here, paragraphs 10 and 11 at page, I think, 3 of 5 in the middle in the boilerplate. But the law as it relates to the assumption of risk, whether it's contractual assumption of the risk or common law assumption of the risk, it's standard law, even in this district, that the person who is assuming the risk, the record evidence must show that they specifically, subjectively understood the nature of that risk. And for somebody who's never been on a treadmill, who's never done this, that's an impossibility.
But under your theory, I go back to having to go around every single piece of equipment, in a gym. Under that theory, you would have to be told, well, here's the risk on this machine, here's the risk on, you couldn't do that contractually. Your contract would be, 50 pages long. You're going to have to, know that there are certain inherent risks in using free weights. There are certain risks in a treadmill, on an elliptical, on a bicycle. I mean, you can't contractually you can't specify that in a contract.
And I don't disagree that should not be the law, that for people who are coming here, that you should not be able to assume the risk that you're not going to be told how to use it, or that the equipment's not going to work, or that it's going to break. I think that's, again, the difference between the assumption of the risk and the release of liability paragraph, which is really the only thing that's at issue in our case. That's the only thing that was before the trial court, and the trial court granted the summary judgment, Judge Cohen, actually sounding very much like your concurrence in Sanislo, indicating that he did not agree with preventing people from making claims, but felt he had to follow the 5th District precedent, which he did. And I'm at the 4-minute time, which went very quickly, and hopefully I'll have a chance to address you briefly again.
Good morning, Your Honors. May it please the Court. Derek Angel. I'm here with Dennis O'Connor, O'Connor for the appellee, Lifestyle Family Fitness. Of course, as this panel well knows, these clauses, while they are strictly construed, they are generally enforceable. In other words, it's the rule and not the exception to enforce these things. Most of the argument that I heard from appellant and was throughout the brief, the initial brief, is that are arguments that should have been made and have been made to the Supreme Court, basically disagreeing with the law on the interpretation of these releases and how they are enforced. Of course, the district here, we are well established that we do not need...
Do you think if the Florida Supreme Court agrees with my special concurring opinion that that's dispositive of this case?
Judge Cohen, I think that's extremely speculative at this point. The Supreme Court, aside from potentially affirming...
No, I'm not predicting what they're going to do. Don't misinterpret that. I'm asking you that if they were to say that, well, the other 4 DCAs are right, and we were wrong, would that be dispositive of your case?
It's difficult to say because we don't know if they're going to articulate a new test for how these things are to be interpreted.
Let's assume, for the sake of my question, that they say that you've got to specifically waive negligence, that it's not any and all causes of action, that you've got to specifically delineate your negligence.
I think in this case, the 10th paragraph, the assumption of the risk paragraph, as Your Honor noted, includes the word negligence. And I think here, because the risk that was assumed by Ms. Kendall was in fact inherent in the injury that was...
Is that part of the basis of the lower court's ruling? Was that argued to the lower court?
It was argued, and obviously the basis was Sanslow, that was the main case, but this language was pointed out in the motion for summary judgment, so we have to assume that the trial court was apprised of this particular language. However, certainly the order granting summary judgment only cites the Sanslow opinion. So as far as what the Supreme Court may do with Sanslow, they could discharge their jurisdiction, they could be writing dissenting opinions to that decision right now, we just don't know. I don't think there's any reason why we need to wait, as they've also suggested in their initial brief, for that resolution. Now...
Why not? What's the prejudice? What's the...
Your Honor, I don't believe that prejudice is the right analysis. I think that it's just judicial administration. And public policy of this state is certainly to, as expeditiously as possible, to resolve our cases, and it really is no different than if we have a trial court setting and there's a dispositive issue in that case and that may be on appeal in any of the DCAs, staying or continuing a trial. That's just not how we do things. I believe that we apply the law as best we can at the day that it's presented to the court.
Well, let me ask you this. Following up Judge Cohen's question, if tomorrow they came out and said, very short opinion, just said the other 4 DCAs are correct You need to specifically reference the term negligence as part of the release. Does that change the outcome of this case?
Again, I think that this assumption of the risk clause saves us here. I think without that, I would agree that reversal would be required. But I think that this contract is certainly more detailed than the one that was in the Sanderslow case.
They argued that language is in the wrong paragraph. It should have been the release from liability paragraph. First of all, do you agree that that would have been the better practice to put that language?
We've never disagreed with that, and I don't think anybody's ever suggested to the contrary, that the best practice, including, I believe, the Hackett decision from this court, the best practice is to include negligence language. But again,
assuming that, given that it's in the assumption of risk paragraph, do you also have to explain the risk before that language can be enforceable?
Just so I understand the question, Judge Evander, do you mean explain the risk in the sense of using all the machines, as we were talking about? I think that it does explain the risk as inherent in using the equipment, the services. It says the facilities, equipment, or services, and that's exactly what happened here. And by the way, her testimony in her deposition was that she stepped onto a moving treadmill, and she was able to navigate the equipment for about, she guesses, between 1 and 2 minutes, and then she falls forward, she tried to hit the stop button, she hit the wrong button, and sped up, something to that effect. I think these are the sorts of risks that are absolutely inherent in using the equipment. And again, these are private entities. Injuries are foreseeable in exercising. It happens that, it's just an incident of physical exertion. And
So if you didn't have paragraph 11, and the contract ended with paragraph 10, do you think you win?
I think in this case, I think we would. I think they're both.
Regardless of, the case up in front of the Supreme Court?
Did Your Honor mean to say in the absence of paragraph 10? I think?
No, in the absence of paragraph 11.
Okay,
If you just
so-
had paragraph 10, assumption of risk, he starts off with the use of LLS facilities naturally involves the risk of injury, and then you go through and talk about waiving the negligence of, including the negligence of the facility. If you only had paragraph 10, do you think you sufficiently explained the risk so that they've assumed them under that paragraph?
I think, in all fairness, if there was no paragraph 11, the argument would have been a little bit different to the lower court. But that notwithstanding, I think we would still be entitled to affirmance because just the use of these machines, that's what the risk you assume. It could be a weightlifting machine, it could be